which is question number 2 from Unit 5. And I will begin by reading it. Ninth juror, the facts are supposed to determine the case. 10th juror, don't give me any of that. I'm sick and tired of facts. You can twist them any way you like. Know what I mean? 9th juror, that's exactly the point this gentleman, 8th juror, has been making. Why are juries required to render a unanimous decision rather than a majority decision in most criminal cases? To what extent, if any, do jury trials ensure the due process as stated in the Constitution and Bill of Rights? To what extent, if any, do jury trials reinforce founding principles? And you may start whenever you're ready.
The one place where a man ought to get a square deal is in a courtroom, be he any color of the rainbow. But people have a way of carrying their resentments right into a jury box. Atticus Finch's lamentation on the conviction of Tom Robinson, an innocent Black man, highlights the central theme of Harper Lee's To Kill a Mockingbird, the paradox of the jury trial. The founders included the right to a trial by jury in Article 3 and the 6th and 7th Amendments to protect against the arbitrary deprivations of liberty experienced by the colonists under British rule. But the right to be tried by one's peers is only as valuable as their unanimous commitment to fundamental fairness.
In a fractured opinion in 2020's Ramos v. Louisiana, the U.S. Supreme Court overturned 1972's Apodaca v. Oregon and mandated unanimity in state criminal trials. The court held that Evangelista Ramos's non-unanimous conviction violated his Sixth Amendment right to trial by impartial jury, as understood by English common law and the requirements of equal justice. When the Sixth Amendment was ratified in 1791, jury unanimity had been a common law requirement for 4 centuries. Chief Justice Story explained in 1833 that because the law presumes every man innocent until proven guilty, unanimity in the verdict of the jury is indispensable.
A single juror with reasonable doubt serves as a bellwether of broader community doubt, demanding acquittal. Furthermore, state statutes circumventing Sixth Amendment unanimity requirements were rooted in historical racial prejudice. As Justice Kavanaugh noted, in his concurrence in Ramos, the Louisiana statute allowed for backdoor peremptory strikes against up to 2 of the 12 jurors, in violation of Batson v. Kentucky.
The Batson Court echoed 1880s Strotter v. West Virginia. The justice can only be dispensed by a jury drawn from a broad cross-section of the community as a bulwark against prejudice. For these reasons, as Blackstone explained, a verdict taken from 11 was no verdict at all. The unanimity requirement speaks to broader principles of fundamental fairness, lying at the heart of the due process clauses of the 5th and 14th Amendments. Due process is designed to prevent arbitrary or erroneous deprivations of life, liberty, or property, and at a minimum requires a fair hearing and notice under Goldberg v. Kelly.
As Thomas Jefferson noted, the mercies of the law ought to be dispensed equally and impartially to every description of man. For this reason, the court held in 1927's Toomey v. Ohio that a criminal defendant is entitled to a jury free of bias or prejudice against him. Jury trials reinforce founding principles in their entirety, as they are responsible for safeguarding the liberty and the rights of the innocent until proven guilty. The oppression of the colonists in star chambers and vice admiralty courts facilitated the various jury clauses found in the amendments and the body of the Constitution. Courts lacked aspects such as an impartial jury and a fair trial, values inherent in the American founding schemes of justice.
Juries are essential in upholding the checks and balances system, as the 2005 case U.S. v. Booker ruled that enhancing sentences by facts not reviewed by juries violated the Sixth Amendment. This ruling reaffirmed the role of a jury in a criminal trial while simultaneously reinforcing the founding principles.
Yet, even with a skilled advocate as Atticus Finch in his corner, Tom Robinson's peers brought their resentments right into that Alabama jury box. That is why it is imperative for the preservation of ordered liberty that we vigilantly protect all due process rights on behalf of the presumption of innocence. It is a sin to kill a mockingbird. Thank you.
And thank you, a sin indeed. So how do you feel about juror secrecy? Would more good or more harm result from making public more details about juror deliberation?
I would argue that it would be a bad thing to make public juror deliberation. The reason being is, as we've seen in the 2016 election, how with politics, how aggressive people can get and violent they can become over politics, and how much attention big cases such as the trial of Derek Chauvin, Kyle Rittenhouse, how much attention that has gotten. It's kind of shown that if we were to reveal these details to the public, the jurors could be threatened.
I
Anybody
agree.
disagree? Oh, go ahead, please.
I agree with my colleague, and for this, I bring in the case of US v. Keith. And although this is a case around central intelligence, I like to bring in that this case specifically points out that secrecy is the essential ingredient in judicial court. It is essential that we have this because this creates a danger of leaks, and this does lead to not protections of the jurors. And this is essential, and that we can't have them make their proper decisions if we are able to have the camera on these people all the time, because it doesn't allow them to make decisions free of bias that they would be held accountable from outside of the room.
But then isn't it sort of fair game for them to bring any, if no one is sort of watching, and this is done totally in secret, aren't we concerned that jurors will sort of decide the case on an improper basis?
No, and this specifically points to the case of 1996, Shepard v. Maxwell, in which First Amendment freedom of the press the media got to these jurors, and this ultimately ruled to an unfair Sixth Amendment trial and ultimately unfair 14th Amendment due process. And because of this, the Supreme Court then can come in, if there does bias that get in there, and can overturn Shepard's conviction, as they did in this case, and allow for a retrial.
Furthermore, that is the fundamental purpose of the voir dire and the veneer, to rule out potentially biased jurors. And if bias does infiltrate the courtroom, as Justice Clark wrote in Reno v. Louisiana, is an impossible standard to require the tribunal be a laboratory, insulated and free from external factors, then they can appeal to a higher court or appeal for a mistrial.
There's an option for a bench trial, and additionally, a Northwestern study conducted in 2014 held that judges' verdicts on a bench trial as opposed to a jury verdict differs 23% of the time.
Sorry, I couldn't find my mute button. I want to shift gears a little bit. I want to talk about jury nullification. Do you think jury nullification plays a proper role in our justice system?
I do not believe jury nullification plays a proper role in our justice system, because jury nullification allows jurors to make decisions simply because they disagree with the law. And this was seen extremely problematic with the 18th Amendment, when jurors would make decisions simply because they disagreed with the bans on alcohol, and therefore individuals were not allowed to have fair trials.
However, historically, jury nullification has played an important role as serving as a final check against arbitrary government, as we see in the trial of John Peter Zenger, a colonial publisher who is indicted on crimes of sedition against the British government, but a colonial jury acquitted him of those charges and was a victory for the freedom of thought.
You mentioned the jury veneer. In terms of having a jury of one's peers, how does the court ensure, or the process ensure, that an individual has a jury of his or her peers? What are your thoughts?
So it's interesting that the language jury of your peers is it's not in the Constitution. That's derived from the Magna Carta. However, we do have aspects of the jury of our peers with the jury vicinage right found in the Sixth Amendment. So the jury is drawn from a broad cross-section of the community, a right upheld in Taylor v. Louisiana, in which it was ruled that the systematic exclusion of women from the voir dire was a violation of that requirement.
Furthermore, if I was born in Ohio, but I committed a crime here in Nevada, I would have a jury of Nevadans, not a jury of Ohioans, because that is the peers in regards to that case.
We believe that the biggest protection against the jury of your peers, because although peers do enter the voir dire process, that does not mean that the exact percentage is going to break out into the actual jury for the case. We do believe the biggest protection against this is that reasonable doubt standard established in Ray Winship. And in this case, Samuel Winship, which was a juvenile, had it established for both adults and juveniles, and not that preponderance evidence standard as customary in civil cases. And this is essential in that if for some reason you don't feel you have a jury of your peers, at least that jury does have to all be unanimous on a decision of reasonable doubt.
Well, in the time we have remaining, let me ask you, we've been talking really pretty much about criminal cases, but there is a right to a jury in civil cases. Would your concerns, the sort of the standards you've expressed so far, would you apply that all of them to civil trials as well?
No, you would not apply them all to civil trials. The reason being is that although in cases like Batson v. Kentucky and Edmondson v. Leesville, the whole peremptory challenge, the Batson challenge applies to civil cases, it's notable that in a civil case, you need a preponderance of evidence as opposed to beyond reasonable doubt, because in criminal cases, you could potentially be putting someone's life away in jail, while civil cases only pertain to monetary funds.
Yes, additionally, civil cases all are there for another specific route. With the 1995 case of O.J. v. Simpson, because they could not find him guilty in a criminal case, this then allows them to take it in the civil case route and get these individuals for money reasons based off the preponderance of evidence standard. So it gives an alternative route.
I would incorporate the addition of an attorney, first set forth in Gideon v. Wainwright, to immigration trials, because since it is a civil sanction, immigrants are not afforded an attorney if they need one. And the American Immigration Council found that only 37% of immigrants nationally secured representation in deportation cases, and they have a much higher percentage of obtaining a new life in the US if they have an attorney and they have access to that attorney.
So you would, so civil Gideon, so they'd have a right to an attorney. Any other sort of protections you would borrow from the criminal system and give to civil immigration litigants?
No.
Okay, we can shift gears. I want to talk about plea bargaining. We've talked a lot about the importance of juries, but most cases never see a jury. They're resolved well before that in the criminal context by plea bargaining most often. Does plea bargaining undermine the important role juries play in our system?
Yes, it does. As seen in Justice Kennedy's opinion in Lafler v. Cooper, he cited that 97% of criminal trials, and this is in 2012, were resolved by plea deals. Furthermore, a study conducted by the Bureau of Justice Statistics, which ranged from 1963 to 2013, held that 8.2% of criminal cases were resolved by a jury, and it changed to 3.6%. And this doesn't just extend to the criminal cases, it also extends to civil cases, because 5.5% of cases were resolved by a jury in 1963 on the civil side, but now it's 0.8%.
But do the raw numbers like that, does that show a harmful effect of plea bargaining? I mean, maybe those cases were appropriate for plea bargaining. Maybe it was a guilty defendant who was getting the best deal for him or herself. Like, why is the fact that many cases are resolved that way inherently problematic?
I do believe that plea bargaining is an issue because the constitutional protection of putting the state at its burden in a jury trial represents the deep commitment to defense against arbitrary law enforcement. And this really helps to have the unanimity designed to protect the cloak of innocence and have prosecution bear the burden of proof. So I do believe these things that we've long fought for, plea deals would undermine these things.
Furthermore, as it was held in Taylor v. Louisiana, the purpose of a jury is to guard against the arbitrary use of power, to serve as a wedge against the overzealous prosecutor. So by allowing the community to have a voice and a say in whether we take away someone's liberty, that is so fundamental, and so many people, the framers, have fought for it for so long.
So I don't know, Judge Shannon, if you have a question, I just wanted to follow up on.
I think we only have about 30 seconds, that's why I hesitate. Go ahead and ask your question.
But why are you, the question from Judge Glickman is why would you assume that there's more unfairness from plea bargaining than from jury verdicts necessarily? What do you base that on?
Because the fact that in a plea bargaining, essentially the community doesn't really have much of a say, because you don't have a jury of your peers the jury of your peers is essentially nullified. in the fact that if you're taking a plea bargaining, then how are the people going to have their own voice, the checks and balances system that jurors play within our system?
Thank you. And overwhelming applause. So thank you very much. I'm sorry, boy, we seemed like we ran out of time very quickly. I really like had an hour's more questions or comments or just things I'd like to explore, but you're sort of faced with telling us everything you know in 12 minutes. Or I guess 14, you get 14 minutes on Monday. But you did, that being the case, you packed a lot into that 14 minutes. I loved listening to you. I loved the back and forth. I loved, you never go wrong starting with Atticus Finch, can you? And ending, it was very poetic. I mean, really, there was a nice arc, I guess, to your opening statement, and the way you ended up where you began was very effective. The reference to In re Winship, I wasn't sure. I knew In re Galt extended the In re Winship principle to juveniles. I'm not sure In re Winship was a juvenile case, but I could be wrong about that. But the point was still a good one. Whether I'm right or wrong about that, but it was really bringing In re Winship and the need for the prosecution to prove every element beyond a reasonable doubt was really a very good germane part. The reference to Justice Clark makes an appearance. That's great. Sybil Gideon, I didn't mean, Mia, I didn't mean to catch you flat-footed on that. I liked your answer. It was the immigration. Really your point, which I took, was that there are, the stakes in civil cases can sometimes be almost as great or greater than the stakes in a criminal case. Or someone who's about to have their house taken away from them would probably not agree with you that we're only talking about money. So and there's a concerted there's a lot of people in this country who believe that there should be a right to counsel in more civil cases than there are. The reference to O.J. Simpson and there was slight almost Freudian O.J. versus Simpson. Many would say that it was exactly the problem, that he was his own worst enemy. I guess I will push back a little bit on plea bargaining. Plea bargaining done correctly and done with adequate safeguards. There are certainly cases, a lot of, like in death penalty capital cases, a lot of times you're worried that someone, to avoid execution, will plead guilty to something they didn't do. And we certainly know now with DNA evidence that there are any number of cases where the system gets someone pled guilty even though they were not guilty. But for the most part, the system literally could not function without it. And so I would just encourage you to take a more nuanced view of the utility of plea bargaining. It's always going to be a part of the system, but it does need significant safeguards so it doesn't get abused. Any event, I make that point because you are such a good, intelligent team, and you were an absolute pleasure to listen to. So thank you.
Thank you so much.
Yeah, I would echo all of that. It was great to talk with you again today. I thought on the Q&A, what I appreciated was you had an ability to bring in supporting evidence from not that precise context, but an analogous context. You brought in the U.S. v. Keith case, you brought in immigration proceedings on that question, and that's what lawyers do all day long, right? There's not always the case that's directly on point. You're trying to find the case that the principles can be applied in a new context, and you showed your ability to do that, which I really appreciated. Yeah, so and then on the jury nullification question, very, very complex question, and you distilled it, I think, pretty succinctly to two answers. Like, it's bad because it allows you to just flout the law based on your personal beliefs, but it can serve an important purpose as a final check on the tyrannical government. I mean, that's the argument, and you consolidated it down to 20 seconds, which was impressive. So nice job overall, and good luck the rest of the day.
Thank you.
Thank you.
I agree with my colleagues. A nice job coming full circle with your testimonial with To Kill a Mockingbird. I hope you've watched the movie and
Yes.
read the book. But I do like the approach you took and the way you responded to the questions. I particularly agree with my colleagues, noting that civil cases are not just about money. Immigration issues are certainly not money, but liberty, opportunity, and other things. So you did a marvelous job there. Good luck to you. Good luck. Thank you.
Thank you.
Thank you for your time.
Thank you so much.
Thank you, Nevada, and thank you, judges.